Hi, good morning.
Good morning.
I think I referred to you as Mr. Austin, but obviously you're not.
I am not.
Apologize.
That's
Your
okay.
first name is not in our report. Raise your right hand. Do you swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
If you would tell us your full name, please.
Sure. Lauren Nicole Alston.
And how you're employed.
I'm employed at NAFCARE as a mental health professional.
NAFCARE?
Yes.
Is that an acronym?
No.
All right.
Would you like me to spell it?
Sure.
Oh, sorry.
Yes.
It's NAPHCARE. Sure. Lauren, LAUREN.
All right, thank you. I've asked for you to be present in court because of your involvement in, not involvement in, but your involvement after an incident that occurred at the jail. Have you been able to familiarize yourself with the report and/or incident I'm talking about?
Yes, I mean.
Okay. If you would please tell me, I think it's the early morning hours, beginning around 4 or so on December 17th. Tuesday morning in the early hours. Can you tell me what your interaction with Mr. Whitehead consisted of?
Certainly. I did not interact face-to-face or auditorily with Mr. Whitehead. At 5:09 a.m., I received a phone call from Falkenberg Jail. I'm actually stationed over at Orient and Booking. So during the course of the night, I actually covered both jails for emergency situations only. I received a phone call that he was threatening to harm other deputies and had spit on a deputy while having blood. So I went ahead and placed him on psych observation.
So when the report says that you initiated a change of status, that's all done via telephone with no interaction with him at all?
Correct. It's I imagine for you, what it might be like is when someone is filing like an injunction. So you're getting information from someone else, you're making a judgment call as to what someone needs safety-wise. So clearly he had, according to what I was hearing from someone else, had made threats against others. I was aware of the high-profile nature of his case due to what's in the media, so went ahead and erred on the side of caution.
All right. Did you have any ideas or suggestions from others that he was suffering from any sort of psychological issues himself?
No, ma'am.
All right. Any questions?
No, ma'am.
Mr. Diaz?
Now, did you review any records as part of making your decision?
So I looked in his chart to see his initial assessment. In there it was listed some previous charges. He had a history of battery. It's part of what we take into account when assessing someone, but no mental health diagnosis.
As part of the records that you reviewed, did you see any indication that he was currently on medication?
I did not look and did not notice if he was on any medications. It would be outside of my purview. I'm a mental health therapist, not a psychiatrist.
Okay. As part of the decision-making, do you look to see if he has any previous diagnosis of any sort of mental condition or complaints of mental condition?
Yes, like I just said, he had no previous mental health diagnosis except for some substance abuse.
Thank you.
You're welcome.
Anything else?
No, ma'am.
All right. You can step down. Thank you, and you're released from your court order.
Thank you.
All right. Does someone have a number for Dr. Disney?
Yes, ma'am.
Do you want me to use that thing?
Yes, ma'am.
How do I do that?
I have no idea.
Good morning, this is Dr. Disney.
Hi there. This is Samantha Ward calling from the courtroom.
Good morning.
Good morning. How are you?
I'm doing well, thank you.
You are here in open court being recorded. We are taking down your testimony. The parties have agreed for you to appear via phone, and I would just ask you as an officer of the court on our court-appointed expert list, do you swear or affirm to tell the truth in this matter?
I do.
All right, and state your name, your full name for the record.
Christina Marie Disney.
All right, Mr. Kane?
Thank you, Your Honor. Good morning, Dr. Disney. How you doing?
Good morning, how are you?
Doing well, thank you. Thank you. You're familiar with the case which you're providing testimony today?
Yes, I am.
All right, so we're here in the state of Florida versus Xavier Whitehead. Is that your understanding?
Yes, that's correct.
All right. I understand that you were contacted by the court to perform an evaluation of Mr. Whitehead regarding competency. Is that your understanding?
Yes, that's correct.
All right. So leading up to your meeting with Mr. Whitehead, did you review any records?
Briefly, I reviewed records briefly last night prior to meeting with the defendant.
All right. And prior to meeting with Mr. Whitehead at Falkenberg Road Jail, you and I had a discussion, correct?
Yes, that's correct.
All right. In that discussion, I gave you a basic synopsis of the facts and allegations.
Yes, that's correct.
I told you that Mr. Whitehead's trial was underway. Is that right?
That's correct.
I told you that he had participated in jury selection.
Yes, you did tell me that. Correct.
I told you that he had interacted with us. He was active and cogent, and that he had participated in jury selection, offering up insight, correct?
Yes, that's correct.
All right. And also, we had talked about the fact that he had a headset on and was listening to juror input regarding media attention in the case. Is that correct?
Yes, that's correct.
All right. I also told you that he had been evaluated by Dr. Farzanigan,
Yes, that is correct.
and that Dr. Farzanigan could not opine on whether or not Mr. Whitehead was competent or suffered from mental illness, but had recommended that he be sent to state hospital for some evaluation and for some observation. Is that right?
Yes, that's correct.
All right. So please tell us at that point what we did and where we went and how we were introduced to Mr. Whitehead.
Sure. So we were escorted to the professional visitation office to get our badges, and then walked down towards the lockdown unit of the jail, which is 3 Delta. We met with the defendant in the professional visitation room. At that time, he was shackled and he was wearing the standard green suit smock. And then you accompanied me when I performed my evaluation with Mr. Whitehead in that office.
Okay. Now we arrived, you and I arrived at the jail about 7:45 last night.
It was probably, I think around, it was around 7:30, I believe.
Okay. All right. Now, how was Mr. Whitehead dressed when you saw him?
He was wearing the standard green suicide smock, designating that he's currently on a suicide watch.
Was he shackled?
Yes, he was.
All right. What was your understanding of whether or not Mr. Whitehead had eaten anything that day, November 17th, or December 17th?
The housing unit corporal mentioned that he had not had any dinner, and then I believe you mentioned that he had not had anything to eat while he was in court earlier in the day. So my understanding is that he had not eaten anything for that day.
Okay. Now, once we sat down with Mr. Whitehead, do you recall my making the introduction?
Yes, that's correct.
All right. And do you recall that at some point I was actually encouraging Mr. Whitehead to join us at the trial table? Do you remember that?
Yes.
All right. So I was asking him to either join us at the trial table and participate in these proceedings, or to in some way reveal to us what was obstructing him from doing that. Do you recall that?
Yes, I do.
All right. So at that point, you started your evaluation of Mr. Whitehead, right?
Yes, that's correct.
All right. Please tell us about that.
Sure. The first few moments, I just really spent trying to engage with him and establish rapport, which proved to be quite difficult. He just presented as someone who was extremely despondent. His eye contact was very poor. So again, I just introduced myself. I explained to him the limits of confidentiality and the purpose for my visit there. But he initially just kept shaking his head, saying that he was very tired, he just wanted to lay down, and he just wanted people to leave him alone. So he, was quite guarded. So I tried to start talking to him a little bit about his family, about his support systems, who he has, what he looks forward to, again, an attempt to build some rapport. At some point, he became more emotional and he started crying. And when I tried to gauge what was going on, he just kept shaking his head and saying, I can't do this, I want people to leave me alone. He made a reference to, everyone keeps messing with me, everyone keeps effing with me, I just want people to leave me alone. So that was pretty much what he was saying continuously. Did not provide a lot of historical information, that's for sure. I was trying to focus on his interaction and what he was going through at that moment, because he just seemed really distraught, and he basically started crying hysterically at that point. And again, in an attempt to try to understand why he was crying, he kept mentioning that everyone is messing with him and that he doesn't trust anyone.
Now, he had made several statements about you all are trying to kill me. Do you recall that?
Yes, he mentioned that everyone, and he kept saying everyone, and when I asked for clarification, he couldn't really give me a specific person or individual, but he said everyone is trying to kill me. He said everyone is calling me a killer. And he mentioned that every time he looks around, he feels like everyone is talking about him. So that was something that came up a little bit later on during our evaluation, that he mentioned that anytime the door closes and he sees someone talking, he hears little murmurs and whispers, and he believes that those individuals are then speaking about him.
And he had included me in that group, hadn't he?
Yes, in fact, that was when he sort of really broke down and almost became like a child in terms of his crying and his emotional presentation. At one point, he started crying heavily, saying, everyone talks about me, even Jamie, referencing, his attorney, you, and saying that you had spoken badly about him and that he couldn't trust you, and that he was really distraught about not being able to trust you anymore because you had basically betrayed him.
And at that point in the evaluation, I asked you if I could have a minute with Mr. Whitehead, correct?
That's correct.
All right. So would you agree that I spent probably about 5 minutes with Mr. Whitehead one-on-one?
Yes, that is correct. I waited outside of the room with the officer.
All right. And after that 5 minutes, I invited you back into the room. Is that correct?
Yes, that's correct.
All right. And in your presence, I had asked Mr. Whitehead to waive attorney-client privilege. Do you agree?
Yes, that's correct.
Do you agree that Mr. Whitehead waived attorney-client privilege?
He did. It took him a few minutes or a few seconds, probably about 30 seconds, and he wasn't sure initially, but then he did say yes, and then you proceeded and spoke with him, or spoke with me about what had occurred when I stepped out.
Yes, you agree that his initial response when I asked him to waive privilege was just do what you're going to do, right?
Yeah, he just had pretty much given up and said he doesn't care what happens anymore. He just doesn't care. He said, do whatever you want, it doesn't matter anymore.
And then when I asked him, and you agree that my next statement to him was that I don't want him just to give up, but I would just prefer that I actually have his blessing and his consent to share that information with you, and he eventually agreed with that, yes?
Yes, that's correct.
All right. So please explain to the court what was shared with you at that point by me regarding what Mr. Whitehead had divulged.
You shared with me that the defendant shared with you that anytime, even when the door is shut and he can't actually hear what someone is saying, he can hear whispers and murmurs, and then he realizes that individuals are talking about him.
And do you remember him talking about the headset that he was wearing during jury selection?
Yeah, he mentioned something about having worn a headset earlier in the day, and even when he was wearing a headset, he also acknowledged that he was hearing people talking about him.
And that he had heard what was being said at the bench during jury selection, and that confirmed in his mind what people were talking about outside of his hearing when it came to their impressions of him as a killer as a result of listening to media and reading newspapers, correct?
Correct. It basically validated what he had been thinking.
And it was after that experience that he decided that he could no longer participate in the process?
That is correct, because he felt as though you were also part of that, and you were no longer working with him or to advocate for him.
Because I was at the bench with those other jurors, correct?
Correct, and in a way you were betraying him, and you were talking negatively about him.
And Dr. Disney, was there any other observation that you made or anything else that you heard from Mr. Whitehead, or any other comment on, well, let me just ask you this. What is your medical conclusion regarding Mr. Whitehead's competency to proceed at this point?
At this point, I do not think that he is competent to proceed, because I just don't believe he would be able to actively participate in his legal proceedings. I don't think he's able to trust the process currently. He doesn't know if he can trust the judge. He doesn't believe the process is truly fair. And then even not so sure he could trust you.
And
so those are my main concerns.
How do you believe that affects Mr. Whitehead's ability to participate intelligently and knowingly in these proceedings, such that he can cooperate with counsel and assist counsel at the trial table in his defense?
I do not believe that he's capable of that at this time.
Do you have an opinion on a mental health diagnosis with respect to Mr. Whitehead based on your observations of him last night?
And again, I have not delved into all of his history in terms of his mental health history. I briefly glanced at the jail records also, which I usually look at the history in order to form, a good diagnosis. I did note it in the jail records that there was some evidence of him having some paranoia in the past, and that he had some depressive symptoms. But in terms of his presentation last night, the first thing I noticed when I saw him, and as time went on, the more time I spent with him, my first impression was this individual is extremely depressed. I believe that he is hopeless pretty much at this point in time. He did not say he wanted to harm himself, but he pretty much said he didn't care whether or not he lived or died at this point. I think he does not have much to look forward to in life. He wasn't able to identify any positive things in life. And I think that his level of depression, his lethargy and anhedonia, and all those different symptoms are also interfering with his ability to have the energy to participate in the process. So the depression, I think, is a concern to me, as well as the paranoia that was evidenced last night by some of the comments he made eventually, and just his overall reaction and behaviors in the jail, and the behaviors that we saw yesterday, I think, are symptomatic of him being very paranoid and distrustful. So in terms of the diagnosis, I would probably rule out schizophrenia spectrum and other psychotic disorders versus schizoaffective disorder, because of some of the mood components that we were seeing.
Did you note any head injuries?
I did briefly see. Oh yes, last night when we were meeting with him, I did see that he had a laceration on his head, and there was some dried up blood in his ear and around his head where he had been in an altercation.
About how many times did Mr. Whitehead say he wanted to lay down?
Oh, I would say about probably at least 20 times.
And that he was tired?
Yes, very tired.
About how long did we meet with Mr. Whitehead?
I would say about an hour and 20 minutes.
Of course it does. Can someone be diagnosed with paranoia and depression at the age of 29 or age of 30 without any history noted in any record of that diagnosis or symptoms of that diagnosis?
I mean, it is possible. Typically someone with that diagnosis will have had some psychiatric history and symptoms earlier in life. But certainly, with stressors and things such as what he is facing currently, those symptoms could be exacerbated and become more obvious during stressful times.
And I understand that you're court appointed and you're acknowledged by the court as a qualified professional to opine on these matters, but could you please tell us what your qualifications are?
Sure. So I'm a forensic and clinical psychologist. I have been on the court appointed list in Hillsborough County this is my second year, I believe, and prior to that I've been on the court appointed list in Pasco and Pinellas County. I've attended the training conducted by Dr. Otto with the state of Florida several times, and I've been working within corrections for the last 10 years with the population that does have an interface with the legal system. And currently, in addition to working as a court-appointed evaluator, I also work as a correctional mental health consultant for a company that provides mental health and medical services to various prisons and jails throughout the country.
So about how many times have you evaluated inmates facing similar circumstances like these?
Quite a lot, I would say. Not only in terms of the competency, but just evaluating them from a psychological perspective within jails and prisons, probably for the last 10 years. So I probably too many to count.
And a lot of that experience was spent at Falkenberg Road Jail?
Yes, that's correct.
I have no further questions. Thank you.
All right, Mr. Diaz?
Good morning again, doctor. Can you hear me okay?
Good morning. Yes, thank you.
You did not administer any tests to Mr. Whitehead to determine if he was malingering, correct?
That is correct.
You are aware of the fact that obviously he has multiple charges, all of them fairly serious. We can agree, correct?
Yes.
It is not uncommon for a person to be upset or perhaps even sad about the fact that they are going to trial if they have such serious charges pending over them. Is that correct?
Yes, that's correct.
Even a perfectly competent person might otherwise be sad or upset about what is coming down the road, correct?
Certainly. I would even think that was quite normal.
Okay. In the case of Mr. Whitehead, you were ultimately asked to evaluate him on the standard 6 criteria, I would assume, correct? His ability to appreciate the charges and the allegations?
Yes.
And I would assume that based on your conversation, he understands that he has charges pending against them and what the general allegations are?
Even in that specific area, he struggled to communicate that. He kept reiterating, everyone knows what my charges are, everyone knows. When I asked him to please rephrase in his own words so that I could assess his understanding, he did not verbatim respond to that inquiry.
Okay, so is it your position that because he didn't say explicitly the words first-degree murder, he is incompetent then?
No, I would not say based on that particular component. It just showed overall his lack of ability to communicate and engage.
Okay. The next common criteria is the ability to appreciate the range of possible penalties. He obviously knows that his life is in peril, correct?
He, again, when I asked what are some potential consequences and what is his understanding of what may happen in the future with this case, he did not give me any kind of responses. He shook his head and basically cried and said that, again, everyone knows what's going to happen to me, and I don't really care what's going to happen to me.
Well, I understand that, but he also expressed that basically they were trying to kill him, his life is over, those sorts of things is what he was saying?
He was saying that, and I wasn't sure though, again, and he didn't clarify if they were trying to kill him based on the charges and the system was trying to kill him, or just people in the jail were trying to kill him, or other people or jurors. He didn't specify who was trying to kill him.
Okay. The next criteria is to understand the adversary nature of the legal process. He obviously understands that people in this courtroom are not working to his benefit, correct?
That was the area too where I have some concerns, because his perspective of the whole system is a bit skewed at the moment. He was not able to articulate that the system is fair. He wasn't sure if the judge was fair. And really, most concerning, he did not, at this time, is not sure if he can trust his own attorney. He just seemed like his attorney had betrayed him, and he was not sure he would be able to work with him anymore.
I want to set aside the concerns about the defense attorney for a moment and focus on everybody else. That's the part I want to talk about in a second. It is not uncommon, I'm sure, in your practice to run into people who think that the criminal justice system isn't fair to them or isn't fair in general, correct?
Well, that is correct, yes.
Even perfectly competent people might feel that the criminal justice system isn't fair to them personally or fair in general, correct?
That is true.
There are lots of people who are perfectly sane, rational, and competent who might hold the opinion that judges aren't fair or that the judge isn't fair in a particular case. Isn't that true?
Yes, I believe that is true.
Okay. So now let's talk about your concerns about his ability to cooperate, work with, or assist his defense counsel. Other than what is reported to you, have you heard any other allegation from any other person at any point in history at which Mr. Whitehead was uncooperative with his attorney and would not speak to him, talk to him, or come out and be part of the trial?
No, just basically from what I heard yesterday.
Okay, but I mean, are you aware of the fact that, for example, a week ago we had a pretrial conference hearing and Mr. Whitehead was in court and refused to answer the judge when the judge spoke to him, but his attorney then indicated on the record that Mr. Whitehead was lucid, coherent, and had been having a perfectly normal conversation with his attorney just a week ago?
Well, I do know that his attorney shared with me that he has been working with him for quite some time. I think the issue is that something occurred during jury selection that somehow changed the relationship.
Okay, so what is your understanding of what changed jury selection?
It seems like something occurred there that made him believe that not only his attorney, but everyone else is talking about him. And when he heard some of the jurors' comments, I think that validated his concerns and his paranoia about that everyone is talking about him and his case, and that everyone is basically against him, and that he would not have a fair chance.
Are you aware of the fact that jury selection that day, I think, lasted maybe 6 or 7 hours in total?
No, I was not aware of that.
Are you aware of the fact that the portion where we discussed with jurors privately at the bench about what they believed to be the facts or understood the facts to be based on media reports occurred in the early hours of that 6 or 7 hours?
No, I did not know any details of the jury selection process yesterday.
Are you aware of the fact that after we went through the media coverage, there was another 4 hours roughly of jury selection where both the state and the defense had a chance to talk to jurors, and throughout the entirety of that time, Mr. Whitehead sat at counsel table without being disruptive or unpleasant or aggressive?
No, I did not know that. It just seemed like he was not engaging very much from what I could tell, but that was just from my understanding.
Did anyone inform you that at the end of jury selection, Her Honor actually asked Mr. Whitehead explicitly if he had any concerns with the jury that had been selected, and that Mr. Whitehead basically said he was happy or fine with that jury and otherwise made no complaints?
No, I did not know that.
Does any of that change your opinion?
No, I don't. It does not change my opinion, because I'm basing my opinion on his behaviors and his responses with me when I saw him during that evaluation.
Is it correct to say that in large part if not entirely, your current opinion is based off of either information that has been relayed to you directly from the mouth of Xavier Whitehead or from his defense attorney who was present with him at the evaluation, but beyond that, you have not reviewed any jail records, prison records, hospital records, mental health records, or anything of the sort?
I wouldn't say any. I just haven't spent probably the hours I should to review all of the records. I did spend some time going over the jail records, as I mentioned earlier, and I briefly looked at some of the records. I didn't read all the hundreds of pages, but I did read some of the pertinent mental health stuff from the jail. But as you mentioned, most of the information that I received is the information from the attorney and from Mr. Whitehead.
And in the records that you have been able to review thus far, you've seen no indication of the administration of prior medications, particularly psychotic medications, is that correct?
It looks like he was refusing and he was not interested in speaking with mental health and most medical staff in the jail. I think he was refusing different blood tests and different assessments, from what I can gather.
Did you see any indications of specific diagnosis by other mental health professionals in any of the records you did review?
I noted that there was some evidence of him having some paranoia and some mood symptoms.
Do you remember what that was related to, what was happening or what was transpiring that led to that diagnosis?
I believe that was when he initially came into the jail, and he was refusing initially to engage with anyone during the booking process.
You might expect a person who's just been arrested and charged with a crime might be unpleasant or agitated, wouldn't you?
Yes, that's true. But typically, once they speak with medical or mental health, they do provide some information because they understand that they're there to help them.
Between the bookend of what happened when he got arrested and the other bookend of what happened since this trial has begun and jury selection started in between, any indications of a mental health evaluation and diagnosis?
From what I can gather, he was doing fairly well. He was being housed in general population until, I guess, yesterday or the day before. I'm not quite sure when the incident occurred. But he basically was aggressive and acted out and was subsequently placed back on suicide watch.
Are you suggesting in any way that any blow or strike to the head Mr. Whitehead may have suffered on Tuesday is now contributing or causing whatever it is he's now suffering from?
No, not so much. I just meant that his behavior has seemingly changed in the last couple days. That, according to what I can gather from my brief review, that his behavior has been adequate. He hadn't had a lot of incidents occurring until a couple days ago, which is when he exhibited some of these behaviors, and then he was placed back on suicide watch, which is where he's being monitored closely by the mental health team in the jail.
But whatever it is that changed his mental state or mood or condition, you're not attributing it to any blow to his head, is that correct?
No, yeah, that's correct.
Are you familiar with people who have received concussions and how they would appear afterwards?
Concussions? Is that what you say, concussions?
Yeah, like blow to the head, you suffer a concussion.
Yes, I don't know if he received a concussion. I do not have that medical information. I was not sure if he actually received a concussion. All I know is that I saw that he had some dry blood in his head, and he seemed to have had a laceration on his head.
I understand, but I'm not a doctor, so you correct me, but a person suffers a concussion, they might, for example, have slurred speech, something like that.
Oh, I see what you're saying. Well, and I'm not a medical doctor either, but certainly if someone had a concussion, those could be symptoms. Someone could have, be sleepy, someone could be dizzy, someone could have some slurred speech, yeah, certainly. But I don't know if he actually had a concussion. I'm not aware.
Other than Mr. Whitehead repeatedly saying he wanted to lay down, did he display anything else that would have led you to believe or given you any reason to be concerned that he might have suffered some sort of concussion?
That really was not my concern, honestly. I was not so much worried about his physical ailment, and more so his emotional response and his hysterical crying and I wasn't so much concerned about the laceration on his head. And again, I'm not a medical doctor, so that wasn't really what my focus was at the time.
I understand. Thank you, doctor. I don't have any questions.
Thank you.
Mr. Green, anything else?
Good morning again, Dr. Dismissal.
Hello.
Now, malingering or suspicions of malingering are not a knee-jerk reaction to these evaluations, are they?
Correct.
Right. I mean, did you see, before you administer a malingering test, you first have to see some sort of indicia of malingering, correct?
Correct. I don't typically use any kind of malingering tool unless I have sort of a suspicion that the individual is attempting to feign symptoms.
All right. So just because an evaluation is taking place after a trial begins does not mean that there's a presumption of malingering on the evaluator's part, correct?
That's correct.
All right. Did you see any indicia of malingering on the part of Mr. Whitehead?
No, his presentation seemed genuine to me. His emotionality seemed genuine. In my opinion, his inability at times to respond, I did not interpret as him being defiant. I interpreted him being in a lot of sort of psychic pain and feeling betrayed and not being able to respond because he was not sure if he could, if anything he said, he felt comfortable speaking because he did not trust anyone.
Now, Mr. Diaz had brought up individuals who routinely are arrested and for reasons on their own have doubts or are skeptics about the level of fairness they may receive throughout their process. Did you see a difference between, say, skepticism and incompetence when it relates to Mr. Whitehead?
I do. I feel I've seen individuals in the past, and again, which is probably at some point people become cynical and their perspective of the court system might not be the best. However, in my opinion, with Mr. Whitehead, I interpreted his presentation more as someone who does not have the capacity to actively participate because of his depression, his lethargy, his disorganized thoughts. Sometimes when people are so depressed, they don't even have sufficient energy to even think clearly and coherently. So that was more my concern with him, that his lack of ability to participate because of his depression and his paranoia, because it's not just skepticism in my opinion with him, it was a deep-seated feeling of betrayal that I saw even toward you that I felt was pretty telling.
Now, Mr. Diaz had drawn attention to my representations to the court as we approached the trial date, where I did not see any indications on the part of Mr. Whitehead in my interactions with him that would give me any pause about proceeding to trial. Do you draw a distinction between how Mr. Whitehead may interact with me personally and one-on-one in our jail discussions, as opposed to how he may be able to sum up whatever is necessary to withstand the stresses and the pressures of a court proceeding?
Yes, I mean, I think that is possible. I am not, aware of any interactions you've had with him in the past, so I did not witness that, but I think that is possible.
Now, is it possible, and I don't know the answer to this because I am untrained in mental health, but can you explain for us how an individual may appear to be competent 2 weeks prior to trial or even 1 week prior to trial and then exhibit or manifest some sort of deteriorating mental status the closer you get to a trial date?
Sure. Well, in my experience, working in corrections, even at Falkenberg Road Jail, what we saw a lot of, unfortunately, was someone would come back from the state hospital, was competent, and then, there is a tendency for the individual to decompensate when they stay in the jail setting for a prolonged period of time. Of course, the stressors of upcoming court dates, that is a huge stressor, and that can exacerbate any kind of underlying symptoms that can make it even worse and can certainly affect someone's ability to think clearly and coherently and to engage with with others.
And notwithstanding what may have been revealed or obvious leading up to today's trial date, when you're evaluating or assessing competency, we're looking at right now, correct?
That is correct.
All right. Right now, your opinion is that Mr. Whitehead is not competent to proceed for the reasons you've already stated on the record. Is that correct?
Yes, that is correct.
No further questions? Thank you.
Dr. Disney, how many times have you testified in court as to competency?
I would have to take a look. I would think at least probably 20 times.
And how long have you been on the court-appointed list in other counties?
Since probably 3 years.
And prior to that, what were you doing?
Prior to that, I was working as a mental health director at the Hillsborough County Jail. So I would frequently conduct different evaluations, big rack evaluations, and I would also work with the public defender's office in terms of consulting with them and referring individuals when I had concerns about someone's mental state or their lack of capacity. And I've been working in the field and doing various evaluations for probably the last 10 years.
Did you ask or inquire of Mr. Whitehead why he didn't participate or answer any of Dr. Farzanigan's questions?
I didn't really address the specifics. I just asked him if someone else had seen him earlier in the day, and he nodded his head. And again, just said that he does not want to talk to anyone because he feels like no one can help him anyway. And he was not very engaging about that.
Were you advised that both attorneys have asked you about the jury selection process? Were you advised that he continually could hear the answers of the jurors that responded in this case?
Yes, I believe his attorney mentioned that to me, that he was able to listen to what they were saying.
And are you aware that some 20 jurors were excused for cause based on the fact that they had read media accounts and believed him to be guilty already?
Oh, no, I did not know that.
Why do you say "oh" in that manner?
Your Honor, if I could correct something here.
No, sir. Why?
I'm sorry. I'm sorry. I didn't realize that. That was just my own personal 2 cents. I'm sorry. I just didn't realize it was such a lengthy process, even hearing about it earlier, that it was a long day, a long process. So.
Well, wouldn't that factor contribute to a defendant's depression or feelings that everyone believed he was guilty if you just heard that number of people say that they'd already formed those opinions prior to trial?
I'm sure that would certainly contribute, and it probably validated some of his fears and concerns about everyone believing that, he's a killer, and everyone believing that he's bad, and basically validating his thoughts that everyone's talking about him.
And some of the factors that you've talked about, his ability to disclose to counsel facts pertinent to his proceedings, to manifest appropriate courtroom behavior, to testify relevantly, those are all equally capable of a defendant choosing not to exercise those rights or those discussions, correct?
There's certainly that could be a possibility if someone is choosing not to. But again, in his case, I believe that he doesn't have the capacity to at this time, based on his presentation.
And based on anything other than what you saw in front of you for the hour and a half or whatever you saw him, are you basing that on anything else?
Of that, I would say 90% of my my evaluation that stems from just from the time I spent with him. And then just the brief review of some of the records that I had the opportunity to review.
And so what's your recommendation then? Should the court find him not competent to proceed?
Your Honor, I think that he should be, go to the state hospital. I think that in a different setting, he would benefit from monitoring and treatment, and I would hope that he would receive a thorough medication evaluation as well, and further evaluation to either confirm or rule out some of the diagnoses that I presented today. And I believe that hopefully the turnaround should not be too long. I would estimate probably about 3 months would be the longest that it would take if he's compliant with treatment and medication. And should be able to be restored hopefully quite quickly.
And what treatment are you talking about that's going to make someone not depressed when they're facing life imprisonment for 3 first-degree murders?
I think, medication management would be helpful. I think with proper medication, he would at least be able to have more energy to participate in his case. He would be able to get out of bed, and he wouldn't be as lethargic as he is currently. And there is also medication that would help treat the paranoia, as indicated. He would certainly, probably in most cases, I would imagine individuals are still depressed in the long run, but they're able to manage the depressive symptoms better, and they're able to develop some coping skills that will help them manage that kind of a future potentially in prison.
And your testimony is that can change in 3 months?
I do think, yes, I think that with medication, especially regarding competency, I think that he would have more energy to participate in the process and in the training. He'd be less frantic, less manic, and less anxious with the proper medication, and I think he'd be able to focus better.
And tell me what conversation you and or Mr. Kane had with him regarding, for lack of a better word, what was at stake with him talking to you versus not talking to you, and the whole finding an issue of competency before this court. Do you understand my question?
I believe I do, yes, Your Honor. Basically, Mr. Kane talked to Mr. Whitehead and explained to him the importance of him cooperating with the evaluation process in order for him to be able to help him better so that he could actively participate in the case. The attorney did not want to necessarily proceed with the trial without the defendant's involvement and participation, and so he tried to explain that to him, that it would be important for him to tell me what was going on and to try to explain to me some of the reasons why he was not engaging and participating as he has been in the past.
Imply that he's less likely to go to trial if he doesn't cooperate with his attorney?
Well, I think he just wanted him to participate in order for him to feel like he could represent him to the best of his ability, trying to explain that to him, that the process wouldn't be as valid without his input.
And certainly if he had exhibited a past diagnosis regarding this paranoia that you term and depression that you termed and past medication or past treatment, that would certainly be significant to your findings, wouldn't it?
Yes, that's correct.
And you weren't given any of that information from court records, from Department of Correction records, from potential family members of the defendant, or anything else, quite frankly, right?
That's correct. I did get some, I was able to review some of the recent jail medical records I did not have a chance to go through the DOC records, but certainly it would be great to have the opportunity to speak to family members or anyone else who's kind of paint a picture of what he was like in terms of his mental health growing up, historical information, anything like that. That is information I did not have.
And you said you didn't view the tape of what had proceeded with the jail incident revolving the altercation that happened. Would it surprise you to know that he approached the victim or the other inmate in this case from behind and hit him in the back of the head?
My question, I guess, would be what caused him to do that? What was his motivation? Was it because of paranoia? Was it because he was worried that that individual was talking about him? Or so those are some of the thoughts that I would want to have answers to, I think.
Apparently from the video, he comes from across the holding cell. They weren't even in proximity to each other.
Okay.
Not
And I
significant
wonder
to...
if you knew the individual or if they had any kind of interactions in the past.
All right. Anybody have anything else?
Yes, briefly. I wanted to clarify something. Do you remember in our conversations before we went back and visited Mr. Whitehead, Dr. Disney, that I discussed giving you a summary of what jury selection was like, and do you recall my mentioning to you that all those jurors were struck for cause, that they were not a part of the jury panel? If you don't recall that, it's fine, but do you recall my saying?
Yeah, I know we spoke about the jury selection, and I don't recall that specific part of you mentioning that.
Okay. And I, as an officer of the court, I will put on the record that...
Any other questions for her? You can make whatever record you want, but is there any other questions for her?
Would you agree, Dr. Disney, that the stress of being or confronting murder allegations cannot be completely eliminated? Do you agree with that?
Can I be completely what? I'm sorry?
Eliminated. You cannot eliminate the stress and pressure of being under criminal allegation and facing a jury trial. That's going to carry with it stress regardless of the person's ability to manage it. Would you agree with that?
Yes, that is correct.
All right. And so would you agree here, or the purpose of competency restoration is to allow and to help an individual manage the stress and paranoia to such an extent that they are competent to proceed?
Yes, it's basically the goal is to assess their ability to currently manage the symptoms that they have, and if they're not able to manage them, as I mentioned earlier, which he does not appear to have good coping skills at this time, then those symptoms are going to take over and disallow the individual to focus on the tasks at hand that are necessary to participate in the process.
All right. Thank you very much. No further questions.
Thank you.
All right, thank you, Dr. Disney. I appreciate you doing this evaluation at the last moment and making yourself available for us.
Absolutely. Thank you very much, Your Honor. I appreciate the time.
Thank you.
Okay, bye-bye.
All right, anyone want to say anything else? Oh, did I not hang it up? Can you look?
The light went out.
Light went out? Okay.
Your Honor, obviously I got out the stuff that I want to get out from Dr. Disney during cross-examination. I know you're paying close attention. I do want to state for the record, the state does have concerns at this point.
What does that mean, Mr. Diaz?
Well, Your Honor, I have concerns that at the end of the day, this will come back. I've discussed it with my office, and that's our opinion.
And I assume that's based on the weight that you're giving Dr. Disney's testimony in part?
Well, yes, and obviously I cross-examined her to point out all the things that she doesn't have and is drawing her opinion, obviously, on an incomplete amount of information. Unfortunately, the cure for incomplete information is more time, so she can look at those things. And I understand what that means. It's not what I want to do. I have all my witnesses here. I'm ready to proceed. We have all of our evidence lined up. I have all of my next of kin's family here. I'm certainly not trying to delay this trial. I have no interest in doing that, but even having read the case law and understanding Muhammad and your court's ruling yesterday, where I had far less concerns, I am generally disinclined to ignore the recommendation of the doctor.
All right, anything else from the defense?
No, Your Honor, defense is moving for this trial based on the foregoing.
Right.
Well, I think you would have to be determined and confident.
Right.
All right, based on the representations of the state then, in joining the concerns of the defendant, I will grant the motion I'll find him incompetent to proceed at this point in time.
Having found the defendant
To be sent to
incompetent,
the Florida State Hospital.
I would ask that Your Honor find that it is a manifest necessity that mistrial be declared.
It is, and the defense has already asked for it too. It is a manifest necessity that trial can't proceed based upon that finding, and the defense has requested a mistrial as well. So that motion is granted as well. Bring in the jurors, please.
Would you like us to prepare the order or prepare our own?
You can prepare it. Just refer to the findings that were made on the record to include as an addendum to the order. I also want monthly reports from the Florida State Hospital. You can add that in there. Every 30 days, I want a report regarding his status.
All rise.
Approach the bench for a minute. Tell you the good news first, because I consider it good news for you all, is that your services are no longer going to be needed to serve on this trial. So I am going to excuse you from your jury service. I do feel like, however, I owe you an explanation since you have been so patient and responded here for jury duty and have been certainly willing, opened yourself to be willing and open to hear the facts of this case. Some issues have arisen regarding the mental health of the defendant to proceed to trial at this time. So we have, after hearing, and that's what we've been doing the past couple days, is hearing from doctors and receiving other evidence. He has been found incompetent by this court to proceed to trial at this time, even though it was in the middle of his trial. He is going to be housed at the Florida State Hospital until such time as his competency is restored. But I didn't want you to just leave and be out there going, what on earth happened? This happens occasionally during trial, as you know and hear in the media. Sometimes mental health issues are related to the criminal justice system in ways that we don't anticipate. But again, I am very sincere when I tell you I very much appreciate your service. I appreciate the fact that you've been so accommodating in our disruptive schedule that we've had thus far. I really sincerely appreciate your responsiveness to jury service, and on behalf of the parties and behalf of all of the judges here in Hillsborough County, I want to wish you a happy holiday. Thank you for jury service, and who knows, I may see some of you in the future in the courtroom should you get another jury service subpoena. So have a great holiday. Thank you.
All rise.
Take care.
Thank you.
Bring the letters.
Okay. I am gonna set a status hearing. In the yeah. All right, I am gonna block a new, trial date, I think, at this time. And we can always cancel it if competency has not been, determined by the state hospital. But I know both of your calendars are booked. The administrative order requires me to do the mistrial, me to do the retrial if I declare a mistrial. So I want to get it, on the books so that there's some end in sight for both the defendant and the victim's family.
Your Honor, first, before I begin, I would ask that you direct the clerk to release the evidence so I can have it back to the
The evidence that's related to the case, the state's case in chief is released, and I'll sign that order.
Thank you, Your Honor.
The evidence that relates to the competency hearing is not released.
In terms of trial dates, I think May is my first month that I do not have another murder set. I have one set January, February, March, and April. I technically have the second half of the murder case set in May, but so I would prefer June, but if Your Honor doesn't want to do June, I have the fund possession set.
I was looking at April 27th.
I have a murder trial set April 20th. I would ask not to do it from then.
Do you have your trial calendars? Do you have my trial weeks thing? Y'all can talk amongst yourselves and see if,
Sorry, Your Honor, you're looking at April or May?
well, I was looking at April, now I turned the page to May.
I have,
Your Honor, I have a first resentencing with Mr. Porter beginning May 26th.
May what?
May 26th. So I guess that would be the day after Martin came in. But other than Memorial Day, I'm sorry, first 3 weeks of May are fine. But I'll just ask that it not be set directly, so May 1st through May 11th are okay.
give me 1 second.
May 11th?
Yeah, I don't think I have anything. I can do May 11th if that's what the court has available.
Give me 1 second. Here's the trial week list.
That would be the week for non-division A, B, C, and D, so E, F, G, I, F.
Where's this case from?
This is a Division A case. Our trial weeks in May would be the week of the 4th and the week of the 18th. That's what I was just looking at. It's an off trial week for us.
What division?
Judge Twain Thomas, Division A.
A.
I mean, our trial weeks would be the 4th and the 18th.
Do you have a preference, 4th or the 18th?
I would prefer the 4th because the 18th is the week before I start.
I'm fine with that.
All right, let's do May 4th. Is that a full week? Yeah. Thank you. And we'll set a dispo date, maybe,
You want to set it the week before?
about mid-March, just to see, make sure he's back or coming back in the near future, so you'll have plenty of notice.
I am in trial the week
Or
of,
May.
You want mid-March? I'm in trial the week of the 9th, I believe, and then spring break is the week of the 16th, so I'm not here. So if you want something like the week of the 23rd or the 30th of March.
We're talking about a status.
Yeah, just a status. Like the last week of March,
So,
like Thursday maybe.
March 26th?
Is that good?
The last Thursday of March is March 26th.
March
Yeah.
26th.
That's fine, I believe it's
All right. And if the defendant is back, then he'll be here, and if he's not, then we'll discuss the trial date reality before you have to get out a lot of subpoenas and things like that.
yeah.
All right? All right, thank you.
Mr. Gasman,
Sure.
if we can go off the record, please.
Sure.
Oh, that's my approach on it, unrelated.
Sure. Oh, good.
He watched a little bit of the live.
Oh, we did?
Yeah,
Oh, that's funny.
So, he said, "Merry Christmas and hello."
Oh, thank you. I hope your family has a nice Christmas.
No, it's right. Across the street. Yeah.
Thank you. Bet you woke up today and had no idea this was repeat. Big deal with the TV board?
Yep.
Well, thank you for offering to play with him.
Yeah. And there was no way to go to
If you want to look at three corners of the right, if there's one way in, that's what I'm saying. We move it to the end sheet here.